Hi, everyone. We're recording this video. Today is November 16, 2021. And this is a weekly immigration talk show called Immigration Talk with me, myself, Anna Sergeeva, licensed immigration attorney, and John Khosravi. We both work for the JQK law firm. And primarily, we deal with family immigration, marriage, green card cases, fiancé visas. We help people with naturalization as well. Today, we're going to talk about very good news that came out last week about H4 spouses and L1, L2s, and E2 spouses getting their employment authorization. Some of them will get incidents of status. We're going to talk about this in more detail. So, hi, John. How are you?
Hi, good to see you. Thanks so much. Yeah, so it's great news. About the employment authorization that we're to discuss right now. We're also going to talk about some DS-160 stuff. This is previous applications and FOIA, how to get COPS applications, because they all kind of go to this to make sure you get stuff right. But yeah, the great news is there was a lawsuit that happened that pushed USCIS to hurry stuff up. So with some background, if you're handling an immigration case, if you have one existing, you know how much things are being delayed. One of the worst aspect was the work permit employment authorization document form I-765. That in some cases, many cases I've seen, because we do some business cases for intercompany transfer, for example, taking over a year to get work authorization or to get the renewal. And what happened is you might have like a L1, this is a person who worked for a foreign corporation transferred to the United States. Their spouse had a work permit, expires. It'll take a whole year to get the work permit again, and they'll lose their job at that point. So it's really ridiculous how long it was taking. And lawsuits happened for them, H4. The lawsuit didn't include the E category, but USCIS went and added that in their policy update. Even though they didn't reference the lawsuit, they just said we did it on our own because we think it's right. So whatever. But it's an interesting thing. What's important to note is not all of it goes into effect yet. So primarily for H4, these are spouses of H1B holders. E's, these are E1 and E2. This is people are investors or people who do a substantial trade with the United States in certain countries. And L, intercompany transfers. If they had an existing work permit and they file a renewal, that filing of the renewal and the receipt that they get for that for the work permit acts as an automatic extension for 180 days, as is if you were, for example, doing a marriage green card and it was taking too long. When in those kind of cases, the C9 category, if you file an extension request on your work permit, by filing, you automatically get 180 days to hold you over. They're saying we're going to apply that to these as well. But the big news is for the E and L categories, the dependents, spouses, not the children. For the spouses, they will be able to have work authorization instant in status, so they don't even need to file for work permit. And this is something that should have been the case for the last 20 years, but unfortunately it hasn't. And it was really disruptive to people because a lot of times they didn't know that you need a work permit and they mistakenly work without what was considered authorization. And then later on, that becomes a violation. They may not even know that it was a violation, so they apply for another visa or extension of status and not mention this violation, then becomes immigration fraud. And it just goes down the road of being disastrous. And to fix that fraud up is going to be very difficult. Now, it's not retroactive, so this new policy does not go back and fix those. And even does not even work right now because USCIS said that they need to create a system and a paperwork for this to show that by having E or L status, you're automatically going to have work authorization. They haven't done that yet. So people in these categories can't do anything yet until USCIS fixes the paperwork, the form notice, and all that kind of stuff, and the I-94s to show it. Now, you might be entering the United States getting I-94 by CBP, the Customs and Borders Protection, which is different from USCIS, the internal agency. But they're all working on updating their systems. We don't know how long it's going to take. But in the long term, this is a tremendously positive thing that's happening in this category. So it was a good news that happened. It was through work of and litigation of a lot of good immigration attorneys that were able to get this.
Right.
And so, yeah, and one thing I mentioned is the issue of previous mistaken violations. And one situation where we see this come up is with previous non-immigrant visa applications. So Anya and I were talking before the show about a client who had mistakenly put a lot of bad information in their ESTA application. ESTA is a special it's not a visa, it's a visa waiver, so that if you're from countries, you don't need to do an embassy interview to get a tourist visa. You could just go online, fill out a form, get that approved, and fly into the United States. But has 7 or 8 questions that are key. If you answer those incorrectly, it leads to you being denied. And if you're not denied and you use it, that could be considered misrepresentation or fraud. And it's the same thing with DS-160s. Could you talk about what the DS-160 is, what's in it, and what the traps are that people get caught in that become consequential later on, Anya?
Right. So DS-160 or 260, 160 is application for non-immigrant visa, right? And DS-260 is an application for immigrant visa, depending on which way you go, right? They're a bit different. But there are all kinds of questions there, including previous military service. That's what we see, that people who served in their home countries, who did their mandatory military service, they answer no to this kind of questions. And in fact, when they have to answer yes, right?
Yeah.
Sometimes someone helps them to fill these forms out, and the provider just don't ask them this question, and they just put this information from what they know, or people mistakenly put this information there, or some people, they don't read the questions, they just want to make everything fast and just submit it and forget about it, because we understand it's hard to deal with a lot of paperwork. Yes. And it's military service, as I mentioned. It's, for example, previous immigration law violations, right? For example, a person can come to the United States during COVID. This happened a lot, right? So a person comes to the United States, gets I-94 valid for 6 months. Usually it's 6 months for the tourist visa, right? And COVID hits and they overstay this time period allotted to them by the CBP officer. And they don't file for the extension because, again, not all people think that this is necessary. Not all people think that this is required. A lot of people thought that because of COVID, they're going to forgive everybody. But this is not the case. The law has not changed, and it stays where it is. And person has violations. So person overstayed his previous for example, during his previous visit to the United States, and now applies for another visa, or, for example, for immigrant visa, or want a green card. Anything can happen, right? Yeah. And people just don't realize that you have to answer yes to this question, because they don't even know that they violated something.
Yeah.
And again, that's where immigration attorney can help you with that.
Yeah, America's really strict on this stuff. And one of our jobs is, it sounds simple, but really to push people is spend the attorney time of having a consultation, talking with them, and saying, have you been arrested? Because as Anya have seen cases, sometimes you got to ask people multiple times to get that answer, and they don't remember or they don't want to say. But we say, for sure, have you done this? Have you overstayed? And we go step by step. We have to go through them, because the military service, I've seen a lot of people forget to mention that. They had mandatory military service. They thought it wasn't a big deal. Well, it is, because by not saying it, America's afraid. They're saying you're a person that has weapons training. You may have been in a country that might be, hostile to the United States, and we're just going to let you in. Obviously, this is a national security issue, which they take very seriously. There's people who don't mention previous marriages. That looks bad. People don't mention having children on the application. And then later on, they get their green card and they want to file for their children. They'll be like, well, you didn't previously tell us about these children. Now, some people watching will be like, who would do that? But it happens all the time. And primarily, as you said, it's because they either don't read English, or they have someone else fill it out who doesn't ask questions, or they're just in a rush to do it because they think it's not important, because many times these forms in other countries are not important. But in America, they're really hardcore in the United States on immigration policy, and they look at all these kind of things, and they will hold it against you later on. So really properly complete a DS-160. If you're doing the ESTA application, make sure to do it right. It's so key, because what happens is you hit with misrepresentation, you're going to have a ban. You have to get a waiver. Not everyone can get a waiver. And so essentially, you'll never be able to come to the United States, and that's done in many cases. And imagine if you're married or your family's here, it's a disaster.
Yeah, I just want to mention that a lot of people, they think that, for example, if they answer, first thing, you have to always honestly answer these questions, right? The first thing is like rule of thumb, right? Yeah. And some people think that if they answer this question honestly, they might not get a visa. This is not necessarily the case. And a lot of visa agencies, that's what they do too. They just don't get this information from their clients. They fill in the forms just to get visas for their clients. They did their job, and that's it. They forget about you. They don't care. What's going to happen later on in your immigration path, right? If you want to immigrate to the United States 5 years later after you applied for this tourist visa with all this misleading information, and it can really hurt your case very, very bad. And
For
as John
example,
mentioned, there might be a waiver required, might not be a waiver required, and it takes more time, more money, more efforts. Families get separated because of that. Yes, and another thing I wanted to mention is for situations like that, it's always good to file FOIA, Freedom of Information Act request. We talked about this, but probably in the previous episode, where you can get all your information that U.S. government has on you, specifically U.S. Immigration Services. But again, it can take time. And for example, there are some deadlines for filing certain applications, and it's not always feasible to get this FOIA result before getting the case out, right? So again, just suggestion, please, if you file for a tourist visa, for F visa, for any kind of visa to the United States, please always save your DS form somewhere on your computer, or you can send it to yourself on your email, or just print it. Have it somewhere saved for,
and
for,
they made
for
it
this kind
really
of
difficult.
situations.
They made it really difficult to say the DS-160. For example, the DS-260 for green card immigrant visa, you could save a final copy as a PDF. For the DS-160, once it's submitted, you can't access it anymore, which is really annoying. So when you're doing your final review, I just save each page on my computer almost as a screenshot, because they don't make it easy, and it's really bad because later on clients come to me, and for example, the L1 that we talked about, the L1. In their tourist visa application, they don't mention previous employment because the travel agent filled it out and didn't bother asking. And then the L1 is a case where you're working overseas for a company and they're transferring you to a U.S. branch. And then so we're here. I don't have a copy of the DS-160. Client tells me they did everything properly, and there's nothing for it'll take forever for me to get a FOIA potentially to get the results. So we file the case and say, okay, they worked overseas, they're working here. And then USCIS comes back and says, well, in the tourist visa application, you mentioned you were not working, or you say you're working for somewhere else. So there's some fraud going on either at the L1 stage or at that previous one. Either way, you're denied, and we accuse you of fraud. So not only do they have to leave the U.S., they could never come back potentially. So it's so key to do this. And there's different kinds of FOIAs. There's a Department of State FOIA, which is harder to get, and they'll probably send a minimal amount of information. There's CBP FOIA from when you're entering the airport customs. Those are really hard to get to. They don't always comply. And they redact a lot of stuff. The best one is USCIS. They're good, but they still redact stuff. And then if you had immigration court, there's the EOIR FOIA, which comes relatively fast, I've seen. But it's important to do all possible if there's a hint of issues with the case, and we don't necessarily do it with every case because there's more cost. And most cases that we deal with don't need it because everything's clean. But if you suspect something with the client or you have the time, it's good to just do it to make sure you did it right, so you know beforehand, especially if you're going to do citizenship, naturalization, for example. People come to naturalization and ask them a question, and as soon as I ask them, they're not positive about something, like, okay, we got to wait, we got to do FOIA, because if we come and file a citizenship application now and there are errors before, that citizenship application could trigger investigations and removal of the United States. Can you take your green card taken away, go to immigration court? So sometimes it's best not to touch it. But I don't want to move this forward. And clients are always in a rush. They want to get their citizenship. They rush. But I said, slow down. We got to do it right or not do it at all. Unfortunately, we see this all the time with these kind of issues pop up. That's why we're talking about this like literally every day. These issues we talk about on this show are things we see actively every day. And there's like Facebook groups, there's things online where you read and people say, oh, it's easy as just filling out a form. I wish it was that easy because I care for my clients. I don't want them to pay a bunch of money and get all this time. I wish it was just forms. But it's just not that easy. We see these disasters every single day at our firm when they come into the
Unfortunately, yes, and attorneys sometimes do mistakes too.
Yeah.
And we had this case where the form, it was adjustment of status form, was not properly filed by the attorney, and the attorney didn't answer the questions. Previous attorney didn't answer the questions the way it's supposed to be answered, and yes, it's a huge mess. And sometimes we can fix it. Sometimes it's not fixable at all. Yeah, and another thing I wanted to mention about this form is criminal history too. Again, a lot of people think that if they have criminal history, they will be denied entry to the United States. It depends. The answer, my favorite answer, it depends. It depends on what kind of conviction you have, when the crime was committed, right? If it's committed before you turn 18 or after. There's so many things about it, right?
Yeah.
But it's always, you have to answer the questions truthfully and just
Yeah.
deal with the consequences.
And if you feel like it's a problem, especially for criminal history, talk with the lawyer, because you got to get all the police records, conviction records, court records, and the lawyer then has to read the statute, the laws as written, compare it with the inadmissibility statute, Immigration Naturalization Act, or INA 212 section, or 1182 at USC 82, and then see whether it falls within exception. If you could argue it's like this, if sometimes the statute's badly written, sometimes it's pled down to a lower offense. There's things where, like, if you only got less than like a year or 365 days, you got, let's say, 364-day conviction, it's different than a 365-day conviction. There's a million and one nuances that makes it complicated. So if it goes in that direction, you got to be mindful of it. And you mentioned the other attorney's work. We do a great job here. We have good reviews, all this kind of stuff. But it is important for a client to take charge of their own case and review their own documents. I don't mind clients asking us questions and reviewing the form and saying, why did you say this? Why did you say this? It's better we catch it before it's a problem than after it becomes a problem. So you have to take charge. You have to read your form. Don't just sign it, assume your attorney did the right thing. You have to go through it together and spend that time. It's time consuming. That's why it costs money, because it spends a lot of times, hours and hours of just reviewing, asking the same question over again, make sure it's there. But that's what you got to do, hopefully, and just get it done one time instead of having issues down the line.
Yeah, and you cannot blame your attorney for later on for something that, for example, you didn't read. If you,
Yeah.
you put your signature, so never put your signature on something that you have not read, that you don't understand. What is this about? If you need translation, you can ask for translation, right, or interpreter to do this for you. Yeah, because it's your signature, and by signing it, you like swear to the contents of
Yeah. And
application or petition.
most immigration judges will say, well, you signed it. And even there are rare cases where the lawyer's mistakes were so bad that it's bad. But if you sign the forms, you means you had the opportunity to read it and correct it. So they're going to hold you to it. So even if you complain about your lawyer and stuff, it's not going to go anywhere. Even the bar might say, well, you signed it. And unless you have, proof that the lawyer like just told you a lie or something, even then, at the end of the day, it is your responsibility. We're just here as guides. And ideally, lawyers won't lie or anything like that. They just work with you, try to do the best they could do if needed. Have the mindset of saying, okay, you have an issue here. We have to file for a waiver beforehand, or with it, or later, and just let them know what's up. There's no hiding this kind of stuff, because the United States does massive information sharing with all governments in the world. Sometimes the computers are slow. It takes them a while to pick it up. We had a case recently where the person shouldn't have gotten a visa. They said no to the criminal history. And it took a while for U.S. government to catch up and put the dots together that this person should have got it. But they're going to get it, and we know they're getting it because there are certain other applications now are pending way too long. It's going to come up. When the travel ban happened, that people call the Muslim travel ban, that affected several countries, particularly Iran, part of the recommendation and the requirements that were made was that every country who wants to get a tourist visa to the United States has to do information sharing with the United States. And this caused all these countries in the world, obviously Australia, Europe, and stuff already share everything, but all these other countries have to open up and share information about their citizens that come here. Now, probably some big, powerful countries like China push back and are not giving it, but some other countries, like Nigeria was an example, bent over backward and said, oh, you put us on trial ban, we'll give you what you need. And so that's why you got to know that they're going to share this information. It's not like back in the days where you could get away with murder, no one find out. Everything is digital. Everything's being tracked. We're in this 1984, Orwellian kind of scary system. It is what it is. We have no control over it. But just know that, this stuff comes back at you. And even, social media stuff, things you post on social media could come. Remember having a client, we're going through adjustment status, everything was good. And then I looked up her Instagram, and she's doing drugs all over Instagram. All these pictures of her doing drugs. I'm like, who would do something like that? It's really stupid. But I said, listen, you're doing drugs, and you have a health issue. It's going to lead to a denial, leading a waiver, all this kind of stuff. And so we had to deal with that and get a psychology report that, or AA and all this stuff that she got better. Go ahead, Ani.
Right. Another thing that I wanted to mention regarding criminal records, a lot of people think that if it's been like 20 years ago, right, or the criminal records were sealed, expunged, or closed, or all these other words, right, for immigration, U.S. immigration law purposes, everything counts.
Yeah.
It's not necessarily will ban you from immigrating or from entering the United States or even from getting a visa, right? But
Yeah.
you have to provide all this information.
Yeah, I'm so glad you mentioned that. It wasn't one of our talking points, but we have people come in, they're in the US, and there might be a student visa, say, well, we did this crime, but we got it expunged, so it's not on the record. And that might be the case where if you're going to apply for a job, you don't have to mention, that kind of stuff. But immigration does not recognize expungements or clearances. You have to say everything no matter what. And this expunges become a problem because many times they'll destroy the documents. And then when they come to us, we say, well, USCIS and State Department want to see a certified copy original of the conviction record, what it was. And they'll say, well, they deleted the file, it's been expunged, doesn't exist anymore. That becomes a problem because we can't move forward. They have to try to reopen the case, get proof from the court what it is. Creates a lot of work, and we don't know whether it's going to work at that point. It's going to be up to the discretion of the immigration officer. So these are really serious things to have the paperwork, all of it ready. And if you're coming into a consultation, having it ready so we get know from beforehand is going to be key. It just speeds things up. But there's no hiding anything. Always be under the assumption that they know everything, and they're just sometimes people say, well, like for taxes, for example, we have to send tax returns as part of adjustment of status or affidavit support. And they're like, well, can't they just ask the IRS? Like, no, they put everything on you. Even if they have access, they're not going to do the extra work. You have to do it. And if they ask for something you don't have it, they're not going to look. They're just going to deny you. It's no skin off their back. They're happy to do it. It's less work for them. They deny your case. They don't have to do extra work. So why? It's all good. So it's preparation is so key. And I feel like it's like such a sad thing we're talking about, but the reality is we just see this all the time, these kind of stuff, and it hurts us. Like when someone comes in happy, they're married, for example, or they want to start a company, and then we're digging into it, things are good, and then we hit a wall with this kind of stuff. It really makes us sad. It breaks our heart. It's an emotional toll. We feel really close to our clients, like family. With one case, Anya, this morning we were talking. Anya, you were about to cry. You're so sad because this couple is going to be separated, and it's you were talking with them. It just broke your heart, and it really does break your heart because these are real people that we're dealing with. It's not one of those things like we're corporate attorneys where we're suing somebody. Even then, we care about the clients, but it's not corporations or something like that. These are real people whose real lives are being affected. Their children, their spouses. It's really a devastating kind of thing.
Yes, when you realize that your clients were waiting for already like year and a half for ordinary 130 position to get approved, and it's just not being approved, and there's something there, right?
Mm-hmm.
And then you realize, you start to dig more that waiver is required for this case, and there is no guarantee that it's going to be approved. The waivers are really, really hard to get. Waivers, it's a petition asking U.S. government to forgive certain violations, like, for example, lies on previous application, or misrepresentation, or criminal convictions, something like that. And it's really, really hard to get. And when you realize that it's going to take like 2 or 3 more years, and there is no guarantee that it's going to be approved and that the person will make it to the United States, it's very sad.
I mean, just the timeline. Let's say even they have a good waiver case and they have the money for it, which costs a lot of money to do. Like if you do the I-130 gets approved, you got to wait for an embassy interview, which right now is taking forever to get. But let's say you get the interview, you get denied expectedly, and then you could file the waiver if you're doing consular processing. Waivers are taking 601 waivers taking over a year right now. And once it's approved, you have to try to get another interview and do that. And hopefully the officer won't find another issue, won't have another problem. And so automatically it's baked in the cake years. And life is short. We have kids, we're getting older. As you get older, you realize time goes by really fast. And so it's like, oh man, I'm just sitting here in my country. The US spouse can maybe come and visit in the meantime, but that's a lot of money, travel costs, they have work. It's just not easy thing to do. So it is a devastating thing, but it could be helped by planning. At least, very least, we could plan it out so we lessen this amount of time, or we just know what works and what doesn't, so people can make life plans accordingly. I've had clients say, you know what, we're just going to move out of the United States and live in the foreign country because it's too much of a headache, or we'll just move out and do the process and we'll live with them until it's done. But at least they know ahead of time is less surprises are going to happen. So these are just important things we want to get out there. And so immigration talks about, it's really to get people eyes open about the seriousness of U.S. immigration and how it affects your individual lives.
Yes. So please take it seriously. If you file for a U.S. visa, take it seriously. It's not just a piece of paper, just to file it and forget about it. No, it's going to follow you till the rest of your life. If later on you decide to immigrate, you know, a lot of times the cases we see that, for example, person were to the United States a couple of times, they had like 3 visas or 5 S's, right?
Mm-hmm.
And through all these 5 S's, the information was not correct.
Yeah.
It was listed there, right? And it's really hard to get with it later on and to deal with it
People
later on.
don't hire us for the ESTA. And it's been one particular case where you spotted issues. You said, listen to the client, let's do screen share. We'll walk through the ESTA together. And they're just answering no to all the stuff they're supposed to be answering yes to. And you're like, wait, what are you doing? This and this. And so people don't hire lawyers for this because it seems insignificant. Most people do it with no problem. We see this with tourist visas, student visas, ESTA. People don't hire, vast majority don't hire lawyers because many times it's not needed. Most times it's not needed. But it's just one of those things. And, you know, even as a lawyer, I just set up a consultation time, sometimes hourly, and I said, listen, let's just go through this together to make sure you didn't say something bad. Because I know you're going to be okay, but my job is to avoid you from saying something bad. Because some countries, my family's from Iran. I've seen this in Iranians and many people in all across Asia, Africa. I have to narrow in on any particular culture, but they're so used to their home countries to hide information because it's always used against them that even stuff that's not important, they'll lie about or not talk about. Even stuff that they say will have no bearing, but they're so used to being secretive about information because their governments crack down so much that they, for no reason, get themselves into trouble. There's stuff that they said was no problem, was problematic. I mean, we had an adjustment of status case. A person came to us that was denied, and they had married a U.S. citizen. Their unauthorized employment, working without permission, is not an issue as long as they don't claim to be a U.S. citizen and get a job. But out of fear that, and they don't know the rules that this was the case, out of fear that the case will be denied, they lied and said, no, we didn't work in the U.S. without permission, even though they were here for 15 years after their visa expired. And so they came to refile the case, and we said, listen, this time we have to tell them, because obviously you were working, but then your previous application, they may say you lied. They may or may not. It's discretionary. They might just say it's not a big deal to let it go, or they may say, no, you need a waiver. But, just looking at them like, it didn't make a difference. You could have just told them that you worked authorization. This person was being paid cash, doing home stuff, cleaning houses or something like that. It was no big deal at all. You could have just said it all day and said, listen, I've been working every day, cash, no problem. And they would have said nothing because it's in the regulations that if you're married to a U.S. citizen, there's always discretion and stuff, but I've never seen a case where it's denied. This is something that they don't care about. But because they didn't know, they lied, and that lie, follows them and creates a lot more work and gets to that waiver stuff. So it's a mess. But
Yes,
really want to work it.
Yeah, final point about that. Please be truthful. And if for some reason you think if you're being truthful and it might hurt you, talk to an immigration attorney, because most times it will not be the case. Yeah, sometimes it will be the case. Yeah, sometimes it will not be the case. Like John just mentioned about the unauthorized employment for spouses of US citizens, right? It's not a violation. It's not going to hurt your case. Again, it's discretionary, but most likely.
Yeah,
right?
I mean, it's rare unless you claim to be a U.S. citizen on I-9 form, and even it just goes up. But if you're not sure, just contact the immigration, talk with them, and get the rules. Contact several people via different opinions, because different lawyers will tell you different things. And sometimes they'll say opposite things, and they're both correct. That's how weird immigration is. But if you're interested in schedule a consultation, just email us at info@jqqlaw.com. If you're watching the video, it's listed under my video. But info@jqqlaw.com, and we'll schedule a time to talk about it and see what's going on. Anya, thank you so much for coming on episode 4. I really enjoyed talking about this stuff. It's kind of like unloading the emotional stuff that we go through, and hopefully it's not too heavy on people, but it's just so serious. We got to put it out there, because I hate seeing these kind of problems, especially when it's not a problem and they make a problem out of something. That's when you want to pull your hair out, because the consequences. It's bad.
Right. So this is very important video, and I would ask you to please share this so as many people as possible can learn about it, and it prevent them from doing some mistakes, some unfixable mistakes. Right. So this is so far it's like episode 4, and probably it's one of the most important episodes that we recorded so far. So please share this video.
Thanks so much. And I appreciate everybody. If you're watching anywhere on YouTube, like, subscribe, and leave comments if you're any particular topics you like talked about. Also catch us on TikTok, Immigration Lawyer John, and our Facebook page, JQK Law, and LinkedIn as well. I guess until next one, God bless you all. Be safe, and we'll catch you soon.
Thank you, John. See you all next week.